The prospects and problems of Madagascar's land reclaim law. On August 3rd, Madagascar's High Constitutional Court validated a law that seeks to reclaim land still registered in the names of foreign settlers from the colonial era. While the decision has raised hopes about decolonization and sovereignty, it has also raised the question of what to do with these lands, reclaiming land in Africa. For readers unfamiliar with the mechanics of colonial dispossession, what is happening in Madagascar is rather common across southern and southeastern Africa. Colonial administrations, working hand in hand with private companies, displaced indigenous populations from their land and converted it into plantations built to feed the colonial metropole. Madagascar's case belongs to this history. However, it is choosing a different model to reclaim these lands. Zimbabwe's Mugabe used a unique method of land retribution. He pursued a populist policy of forcible seizure of white-owned farms. Namibia adopted a willing buyer, willing seller system, where compensation is surely made. In South Africa's model, legislation allows expropriation under specific circumstances, and the balance has not changed much. Madagascar has taken a fourth path. Rather than confiscating land currently owned by foreigners, the new law targets titles that were abandoned in foreign names at independence on June 26, 1960, and never transferred to a Malagasy owner since. After the court ruled in 2015 that transferring colonial land directly to private individuals would be unconstitutional, the country has taken a new path. It will transfer such properties, except for diplomatic property, those owned by settlers who later took Malagasy citizenship and parcels already transferred before independence. History of colonial titles. To understand how we got here, let's go back to the brutal history of how these titles came into being. Following the 1896 occupation of Madagascar, the French administration under General Gallieni dispossessed indigenes of their ancestral lands and forced their emigration to other regions. Compulsory land registration, introduced in 1911, dealt a further blow to lineage-based ownership by making land an individual, titled commodity, while land used for tavy cultivation or grazing was reclassified as state property. Land grabbing in Madagascar was so severe that by 1923, provisional and definitive land grants to colonial companies had reached nearly 1 million hectares. Some dispossessions were carried out by paperwork as much as by force. Now, sitting untouched in French names, the new law moves to unwind them. How to read the new law. Many people, especially Pan-Africanist commentators, have welcomed the ruling as an overdue act of decolonization. It indeed calls for optimism against the legacy of French colonizers. But the end and the process of what becomes of the lands really matter. For instance, Zimbabwe's land reclaim was catastrophic not only because of poor planning, but because of corruption, where merit was the least important criterion for distribution. In South Africa, the few lands given to the indigenous black people could have been able to compete in productivity, but this has not always been the case, as proper use of the land has not always taken place. In Madagascar, one should not expect magic either. Something more critical deserves attention in Madagascar. This country has seen, in the 21st century, a history of land grabbing by foreign corporations. For instance, the notorious 2008 Daewoo Logistics affair saw a South Korean conglomerate seek a 99-year lease over 1.3 million hectares before public outrage forced the deal's collapse, only for the company to continue operating through a local nominee. Malagasy civil society, through groups such as the Collective for the Defense of Malagasy Lands, has long warned of the opacity surrounding land contracts granted to foreign investors and the corruption that accompanies them. Hence, reclaiming a colonial title from a defunct settler company means little if the land is simply handed over to a new corporate lessee without benefit to the masses. The government's own agriculture, Livestock and Fisheries Sectoral Program has previously championed long-term land leases to foreign investors as a development strategy, a posture Malagasy civil society has condemned as selling the homeland. But for a country where around 85% of the population puts food on the table through agriculture, and 70% of the population is rural, where the average farmer works barely 0.15 hectares, a distribution that will effectively reach the people is sacrosanct. Whatever the case is, handing title deeds to peasant farmers without financial facilities and infrastructure, and especially without creating a market for goods, makes the effort futile. In conclusion, Madagascar's law alone will not undo the deeds of French decrees. It is a good step to avoid Zimbabwe's upheaval and Namibia's market-based patience altogether. However, the Malagasy government should be ready to reap the fruits of land redistribution by creating a good environment for agriculture. If not, they will only be the laughing stock of their colonizers.